unknowingly.
Yes, we do.
And so people say, why is there terms and conditions in the credit application? Because that's life. Life has terms and conditions. So if you want to grow old, there's terms and conditions. There's certain things that you need to abide by to get there. If you want to be healthy, there's certain terms and conditions you need to comply to stay healthy. And everything, without you realizing it, there's terms and conditions attached to that.
Absolutely. And I agree with you so much. Everything that we do in life is rule, and that's really what the terms and conditions are all about. So that's what we're going to be going through today, is the rules that have been put in place or that need to be put in place, the regulations that stipulate what those rules are. And then, of course, just to make a disclaimer, myself nor Martin are lawyers and or studied law in any way, and we do recommend that you consult an attorney should you want to do or redo your terms and conditions. Of course, we can help you with what we've seen in the industry, but we are absolutely not lawyers, and this would need to be drafted by a legal team to make sure that you have all your bases covered correctly. This is to give you a guidance of the things that you should be looking for, so that you can make sure that you are sorry, I see a lot of people are joining, sorry, to make sure that you are covering yourself, making sure that there's no reckless lending, and ensure you comply with the rules and regulations of the country, which is very important. So
Also
let's
more
begin.
specific, Amy, to their industry, because there's some, you see, the terms and conditions are basically in three categories. The first one is the general terms and conditions, which is where my address of business and my consent that I give to you to do a credit check on me, and things like that. Then you get the financial ones. This is the terms, this is the credit limit, am I charging interest and anything like that. That's the second part. But the middle part, which is industry specific, is something that needs to be done in conjunction with your company operations and a legal team that's going to help you to set those rules in place to say, in our industry, this is how we operate. In our industry, this is what you need. For instance, let's just use a simple example, the liquor industry and a liquor license. So the first thing they'll say, if you can't trade with us if you don't have a liquor license. Simple as that. But what does a liquor license mean to a logistics business? Nothing. It's a completely different industry. But that's
Unless
what
they
I'm
are
saying.
drinking what they are transporting.
Absolutely. Absolutely. So all over to you. Let's start this thing and let's get it rolling.
Absolutely. So we do have quite a lot that we need to cover today. So we're looking at the agenda. We're going to be looking at the introduction to credit applications, the terms and conditions of those applications, surety agreements, ownership of property and goods. And this is obviously specifically if you trade with a tangible product. If you trade within a service, it's really difficult to get that back. Or actually, it's actually impossible. Be like, no, give me back my training. Okay, and then practical applications and case studies that we've seen happen before. Okay, so let's jump right into it. Okay, so from an introduction to credit, this is a lot of information. Don't worry, we will post this with the recording. But essentially what we're saying, a credit application is a legally binding contract between the credit provider, that would be you, and the debtor, that would be your customer, such as a business or a sole proprietor, where the credit provider agrees to supply goods or services on credit, and the debtor agrees to pay for these goods and service at a later date, meaning what are those terms that you're going to provide. So the key elements that get built into this credit application are your credit limits. So you would then decide, how do we set credit limits? What profit margins would we be making? What pricing would be used for those credit terms and credit limits? And that's what you need to consider. Then, of course, your payment terms. So what does your company allow? Is it 30 days from statement? Is it 30 days from invoice? Is it 7 days? Is it 14 days? What are the terms that you're able to provide? Then we look at confidentiality. So confidentiality of, sorry, I'm just admitting somebody over there. Confidentiality, so the protection of the information. So obviously you are going to be requesting some very important information, and you might be giving some very important information. So confidentiality is extremely important. And then obviously termination clauses, and this would be from both sides. So what would happen in the event that the customer did something or the debtor did something which gave you a reason to cancel the agreement, or you want to cancel the agreement because the customer didn't fulfill their portion. So it needs to come from both sides that you would be able to then exit the agreement with rules and regulations. Okay. Then we also look at the importance of the credit application in business transactions. So we specifically focus on B2B because majority of you on the call are B2B companies as opposed to B2C, which stands for B2B is business to business, B2C is business to consumer, and most of us are not business to consumer type industries, okay? If you do trade directly with consumers, that's also okay. The same rules do apply, and you'll see that we do include a little bit of information around that, but that is not the core of the credit industry. Okay, so what we want to do is the importance of a credit application is to make sure that we're facilitating the growth of your business as well as the growth of the person purchasing from you. You need to be able to build trust. And we speak about this all the time, myself and Martin, in terms of this is a contract between the two of you, but it is also a relationship. And all relationships are built on trust. There is that element. Of course, we can get the, crosses our T's and dot our I's, but you still need to be able to trust the person that you're about to do business with. Then risk management, so making sure that we are going through all the processes that are dictated in our credit policy to make sure that what are we able to do, where can we extend ourselves, and what checks are we going to put in place? Is it going to be financial analysis? Is it going to be credit bureau information? Of course, there's going to be Trade Shield as well, and all of that information to say what are we going to do to mitigate our risk. And then our legal protection. So what is the process that we would follow to ensure that we are legally protected? And that would be in terms of if we give over our goods, how do we ensure that we get paid? So very important. And then, of course, if we don't get paid, what is the process thereafter? What legal action do we take when we need to take a judgment or hand you over, etc., etc.? So very important. These are the areas that you would need to focus on within your credit application. Are there any questions or comments from anyone just yet?
Can't see any questions, Amy.
Okay, perfect. Then we look at the National Credit Act. So this is very important. We need to ensure that we are compliant with the NCR. So the purpose of the NCR is to make sure that there is a regulation around the credit industry. And this is both for the consumer as well as for the business to business market. So they have their own rules and regulations to make sure that you are following the laws within the country. So this applies to all credit agreements and credit providers within South Africa. If you are trading cross-border, you may then need to look and see how would that affect your business, but essentially you are still regulated within the country, and therefore they would need to comply with your rules and regulations as well. And then, of course, there's the previous information. So the NCR has replaced the Usury Act and the Credit Agreements Act, consolidating all of the consumer credit law. So all of that is involved as well. And actually, if you can go onto their website, the NCR website, and they have a lot of information around credit information. I will post that link as well for you to be able to see what they recommend as well to ensure that you are following the rules and regulations. Okay, then we do have some bodies that are the governing bodies besides the NCR, but there are other areas that you would need to then comply with their rules and regulations. For example, we spoke about the NCR, so this oversees the consumer credit industry as well as the B2B industry. So any credit bureau, like for example, our sister company Inoxico, would need to comply with the NCR's rules and regulations, as well as their protection of data, as well as how we provide information. So I'm sure you've heard often to say, oh, why didn't we give you this information? And that's because we have rules around how we can do that because of the NCR's regulations. So we need to comply as much as you need to comply as well. Okay. Then we've got the National Consumer Tribunal. So of course, this is an independent body that works across South Africa, specifically looking at sole proprietors or the consumer. So anyone in the B2C industry or anyone dealing with sole proprietors, which is very important because we do have a lot of customers on the line who do deal with sole proprietors as well. So if you don't know the National Consumer Tribunal, again, you can also visit their website and they are able to guide you as well. Okay.
There's a Consumer Protection Act as well, Amy?
As well, yes,
yeah,
absolutely.
And the Consumer
we'll get
Protection
to that
Act.
later.
Oh, is it later? Is it in there?
Okay. It is, but you can say it now.
Yeah, the Consumer Protection Act is like you have the National Credit Act, or the that is more for business to business, and the Consumer Protection Act is more for the end user or the sole proprietor that could be an end user as well in that case. And how does it protect that person against the purchases that he has made from you or from a business?
Absolutely, absolutely. Thanks, Martin. Okay, so here you can see that we also then go forward into say what are the different types of credit applications. So you've got secured and unsecured loans. So that might be that where if you've taken a secured loan or secured process within your credit application, because either you are fully credit insured or they've signed surety. Unsecured loans means that you are taking the risk, okay? And you would then need to go ahead and have, all your checks and balances in place if you do not have any securities whatsoever. So we do go into what those different types of securities could be. It could be money, it could be overdraft facilities, it could be, assets that can be sold or pawned as well. And then, of course, mortgages against properties as well. There are also sessions of books that you can get, personal sureties as well. So those are different kinds of things you could look at. And then, of course, the installment sale agreements, so agreements where the goods and services are sold with payment deferred over time. This works the same in terms of the consumer side. So you say you can have the stock and you need to pay it to me within this period of time. Okay. And then we've got the consumer rights and responsibilities. So that's exactly what we were speaking about a second ago. So the NCA outlines the rights of a consumer. And this is also very important when it comes to credit applications because of the changes that happened within the government. I think it was last year sometime. Time goes so fast, it could have even been the year before, where the Consumer Protection Act came into play. And that had a huge effect on how we purchase on credit, and where the government now leans towards the consumer as opposed to leans towards the businesses themselves. So anyone in an industry like, for example, the clothing industry that had clothing accounts, they need to be very careful around the Consumer Protection Act. Okay. And I would even say that a person is able to play, excuse my wording, but dumb. They're able to play dumb in terms of, oh, I didn't know that, or oh, I didn't see that. And because it's not a proof type environment, it's very difficult to then fight those cases in court. Okay. So here we want to make sure that we have compliance regulations that the person needs to adhere to, and of course the Consumer Protection Act as well. Okay. Oops, did I go the wrong way? Apologies for that. Okay, so now we're going to talk about the terms and conditions. So here inside the terms and conditions, as I said before, that this is a legally binding contract between you as well as your supplier. And here we're looking at the different elements that need to be included. And we need to then go ahead and look at different rights and obligations between both you and the debtor. So you are the creditor and they are the debtor. And so here there's obviously the creditor's rights. That would be your rights. So this would be to receive timelessly payments as per the agreed terms, to change the interest and the penalties at late payments, and this obviously needs to be stipulated beforehand to say this would be the consequence if you didn't do X, Y, and Z. Okay. You would also then be able to, and also we spoke a little bit about this previously in terms of who is allowed to charge interest and how does that work if you are not a registered credit provider in terms of like a bank. Okay, so you would need to understand what that looks like. It could be a late payment penalty, that you phrase it very differently. And then how, as I said, how to terminate that agreement. So it needs to be specified under the terms and conditions. And then, of course, the retaining of ownership of goods. And this is very important if you trade in a tangible goods industry. You want to make sure that you remain the owner of that product until it is sold. You also need to be able to prove that this tire belongs to you and this one wasn't paid for, but this tire doesn't belong to you anymore because it was paid for. So there needs to be an understanding or a barcode or some way of tracking to see that is actually a product that was purchased and paid for.
The legal terminology is reservation of ownership.
Reservation of ownership.
You've got to
right.
prove that that specific item belongs to this unpaid invoice, because if you can't, you're going to have a problem to enforce that law or enforce that rule in your credit application.
Absolutely. But then you as well, so not only do you have rights, but you also have obligations to fulfill. So you have a promise that you're making to the customer to say that I'm going to be providing you with goods and services as I agreed to. I will disclose all my terms and conditions very clearly, and to protect the debtor's personal information in compliance with the Personal Protection Information Act, or the POPI Act that we've all spoken about as well. Now, the POPI Act is a very interesting one in terms of it is personal information, so you do need consent, which needs to be a part of your credit terms and conditions, or if you do use TradeShield, then of course it is part of your workflow and it is a mandatory field, because this allows you to capture the person's information. So just so you understand, you're not going to take this person's information and post it on social media or sign them up for something they didn't actually sign up for, but you need to have their permission to actually save their name in your system. So if you need to send them an email, if you need to talk to them, you need their permission to save that information. But what does not fall under the POPI Act is information about the business. For example, financials. That is not a problem with regards to POPI, because it is not in the person's personal capacity unless it is a sole proprietor. And if a sole proprietor is choosing to trade as themselves, again, it does also override that POPI Act as well, to make sure that it is not personal information. It's specifically about the business. So things like bank statement, things like financials, who the directors are, what their IDs are, how many businesses they own, what statuses those businesses are at, and of course, any judgments against the business. None of that is POPI. That is statutory information about the business. So if somebody says to you, sorry, I can't give this to you due to POPI, that is an excuse and not actually the law. Okay. Then with regard, and I know we have had an attorney come and speak to us about the POPI Act, and we will most probably do it again later on. If you'd like to see that recording, it is in the Knowledge Center. So you can go and see what information you can use against to protect yourself, as well as what information you as a business would need to give over if you are taking out credit with another company. Okay, then we've of course got the debtors side of things. So they've also got rights to receive the goods and services as agreed, to be informed of the terms and conditions without any strange little hidden clauses, and to have their personal information protected if they give you their permission. Okay, and the debtor's obligations are, of course, to make payment as per it was agreed in the schedule and comply with the terms and conditions within the agreement, and provide accurate information during the credit application process, which is absolutely key, because when you're onboarding that customer, you need to make sure that you have the correct information. So if you are still using a paper-based type credit application, you need to ensure that everything is filled in as it is required by your business. Okay. Let's talk about surety. Very exciting. So surety is always a point of contention, and why customers tend to either delay the process within their credit application, maybe they don't understand it. And if you have ever signed surety and you've left a business, then what is the process? Sorry, before I continue, I see that Melanie asked a question. She said, if customers refuse to attach their audited financials and the reason is we don't send our financials, what other alternatives do we have? So that's a great question. So us at TradeShield can offer you two things. Either they can send it directly to us for assessment, where we will then be able to give you just the outcome. The other thing we can do is we would be happy to do an online audit with them. So either Martin or one of our other credit executives will sit and do an online audit with the firm. And again, we would then be able to provide you with the outcome without giving you the details. So sometimes they do feel that it is confidential and they don't want you to see certain information, and therefore they are concerned. So if you want that to be an option, then let TradeShield step in. If they do not want to send it directly to us, or they do not want us to do an audit for them online, and or if it's a very big deal, we're happy to go in person, then obviously the credit limit that you're able to provide them will be much lower, because it's like saying, can I have R1 million, Melanie? I think I'm a nice person. I brushed my hair this morning. Will you give it to me? But I'm not going to tell you how much I earn, and I'm not going to give you any proof that I even have a job. You're going to say, are you insane? And it should fall the same thing here. If the person doesn't want to say how much they can afford, they have to start out either COD or at a much lower limit than was requested, because you also need to ensure not to lend recklessly. Hope that answers your question. Okay. Perfect. And Neil has also just popped into the chat there for us to say, what are those two options, as well as signing NDAs. So we're happy to go the extra mile for you. And you can see that information in the chat. Thanks, Neil. Okay. So let's talk about surety. So what is surety? Surety comes and says, what can I give you as collateral to say, if you're going to give me this, and I'm promising to pay you, but if I don't pay you, what would the consequence be? And I feel like I'm being somebody's parents, but that's essentially what we're outlining. We're outlining what is the consequence of not paying. What course can we take? And this could come in multiple different ways. So surety is generally what we're talking about is personal surety. So if I am a director and my company has been registered as a private company or a public company, so anything PTY, for example, then the directors are not responsible for the debt in their personal capacity. So if they don't pay you, you can't be like, I'll come and take that Lamborghini that you're driving. Okay, so personal surety says, I will come after you in your personal capacity for your personal assets to settle outstanding debt. And that is why somebody would be hesitant. But if they are hesitant, then the question is, why is that? Are they not comfortable that they're going to be able to pay you back? Sometimes it is a very, very large firm as well. And then I do understand it is a very large company. They can't sign surety for everyone. But even if someone does sign surety, we need to ensure that, who have they signed surety with? Because if I've only got one Lamborghini and I sign surety with you and you and you and you, is it going to be actually viable? And then who would be the person who would actually go and take that asset if we needed to? So it would obviously be the person we sign surety with the very first time. So we want to then, if somebody does sign surety, and in your surety document, you should ask, had they signed surety before and to what value? And a surety document is still valid even if the director leaves the business. And I know, Martin, you've spoken about a case where somebody actually did sign surety as the director of the business. They then resigned a couple of years later, and the company defaulted on payment, and they went after that director who had still signed surety. So if you are a person that does sign surety, it is in your best interest to make sure to say, I am leaving this business, and therefore you need to get signed surety from this person. So that is up to us as a business to ensure that if there is a change in directorship, we need to see who signed that surety document and ensure that it is still valid for us. But good practice would be to go and get an updated surety document. Okay.
We've got a question from Neil, Amy.
Yes, I can see that. Neil, are you just wanting me to look at the question that Busisi Ware posted? Okay, perfect. So Neil is actually sitting right next to me. Okay, so Busisi Ware says some customers have objections to the terms and conditions during the credit limit increase process. I've previously advised that they strike through those they do not agree with and attach the PDF of the T's and C's. Let's see, T's and C's. Are customers able to move past the stage in the credit application, and how do we resolve this? Okay, so BCC, where it's an excellent question. So you're specifically talking about when someone disagrees with your terms and conditions within the TradeShield platform. And when it comes to that, we do have an option to negotiate. So it's a feature that is either enabled or disabled. Some companies just say, "Foots, toots, take it or leave it," and therefore that information is not available on the system. However, if your company allows for negotiation, then there is that option within the system, and it will go to whoever in your company is able to negotiate with them. So a legal team, for example, and they can go back and forth to say, these are non-negotiable terms and we want to move forward, or we're happy to negotiate, and these would be the updated terms and conditions that need to be signed. And so that can take place within the system. If this is something you'd like us to show you, we can set up a time with you and we can take you through what the disputes of the legal terms and conditions process looks like. And then again, it's up to your company if you would like to enable that. Yes, Martin.
All right. So just a bit on that and on the terms and on the surety. So first thing, a surety document, a personal surety, does not make you a preferred creditor. So if you should decide to liquidate the business that you are trading with, the debtor, with other words, you are not going to be a preferred creditor. It's not a tangible document. It's not a tangible security. It is just a surety. But if you do want to make sure that the surety is worth something, ask for an assets and liability statement from the person who signs the surety. With other words, what do I own and what do I owe? So that you can see that there is assets available to you that is going to cover you in the case of you then going after them personally, because you might go after them personally and find out that they owe the whole world and they own nothing. Then your surety is also worth absolutely nothing, and you wasted a lot of money going after a person. Okay, but if it's just as a nice to have and you put it in there and you've got it, it's good, but it does not make you a preferred creditor. And the very important thing is, Amy touched on it, is when you start allowing clients to draw lines through your terms and conditions, make very sure that it is agreed to by your credit policy or the way your business is set up. Do not just accept it on yourself, on your own bat, and then open the account and then at a later stage find yourself in very, very hot water. Make sure that you are doing this in accordance with the company's rules and credit policy. Thank you, Amy.
Absolutely. Thanks so much. And there were some messages for you, Neil, in the chat. I'm sure you'll get on them straight away. He's giving me a thumbs up. Okay, perfect. So there are different elements here that you can see. And of course, as I said, there are different types of securities/surety. What's very important, and we obviously give this information over to you, is do not hide personal surety as a clause in your terms and conditions. And because of this, the Consumer Act will always side with your debtor. So for example, if it was just clause 1, 2, 3, 4, 5, somewhere sandwiched in between, and then it comes to reclaiming that money, the person can say, oh, I didn't see it. And the Consumer Protection Act will then side with them, and unfortunately, you will not be able to claim it. So we very much make sure that a surety document has been explicitly noted, and so that you can make sure that everybody is aware that they are signing surety. So you'll see that we recommend that it is a totally different document. We also recommend that due to the fact that it is something so important and there might be multiple people that would need to sign, that this document is downloaded and what we consider wet signed, like a physical old school pen, and then re-uploaded into the system to make sure that you've covered all your bases. So here you can see there's the scope of the liability, the duration of the suretyship, which is also important. So when you are saying, How long is the surety document valid for? It could be indefinitely, which if I was signing surety, I would probably not sign that. Or if I was a company, I would definitely want them to sign that. So just make sure that these are the things that you've done. So identifying the surety, what is it? The scope of the liability, as well as the duration of the suretyship. And then, of course, there are the legal requirements, which is the compliance with the Consumer Protection Act, as I mentioned earlier, making sure that we are being exceptionally explicit about what they're signing for, and then clear and ambiguous terms. So making sure that we use very, very interesting, plain and simple old English. I know a lot of legal terms can always get quite confusing, but we need to be able to make sure that we are speaking the average person's English, that anyone like myself who's not an attorney would understand. Neil, you have something you'd like to say?
I think
Okay.
he's wanting to talk to you about there's a question,
Jason
what
has
is
a
the most
question.
unfavorable type of suretyship?
Excellent question, Jason.
I think we've spoken about it. The most unfavorable type of surety, if that is a suretyship, is a personal surety. Sureties is the various. I will call them all unfavorable. Why? Because there's a lot of work attached to them. So you got to do certain things to make sure that that thing stays in place and intact. For instance, let's use a notarial bond. A notarial bond says, I have access to all your movable assets if you don't pay me. Now, if I don't go and check that you have movable assets and I now want to claim on it and I come to your site and there's nothing, my whole security means absolutely zero. Same thing with a session of book debt. If I don't every now and again go and check your debtors ledger to understand that you've got debtors, that they're in a good paying format, they're paying you well, that should I need to claim against you and I go and take my session of book debt up and I go to the courts and I institute it and I go and collect the debtors to make my debt less, that there was something like that. So there's a lot of work attached to it. I can call it unfavorable, but the only thing that I just now said is a personal surety does not make you a preferred creditor. So if you want to classify it as the most unfavorable surety, that's the one I would say is the most unfavorable one. But all sureties can count and can work against you. A bond over property, notarial bond, personal surety, cross-company guarantee, credit insurance. There's so many different ways to secure your debt. And I think we will have a session around that in a later stage. Thank you, Amy.
Absolutely. Thank you, Martin. And Jason, I hope that answers your question, that when someone does sign surety, that it is an ongoing homework project for you to ensure that if they've signed with you a property, do they still have that property? Is that property still valued at the price that they've signed for it? So there's a lot of homework that Martin is saying. So it's not just go check somebody's debtors book. It's you have to be constantly monitoring. And that if they've signed in terms of movable assets, are those assets paid for? And then that falls into the same category of, who do those goods belong to, and can you even take them? So surety, even though somebody may have signed for it, they may have nothing to offer you as well. So very important to make sure that you do your homework thereafter. I hope that answers your question, Jason. If not, pop us a message in the chat and we can talk about it. Yes, I see, Richard, you have a question. Go for it. Let me see if I can unmute you. Apologies. There you go.
He must now unmute himself.
Yes, Richard, you can unmute
there
yourself.
We go.
Okay. Good morning. My apology. What I wanted to ask, in fact, it was going to be difficult for me to type it.
No,
okay.
Go for it.
Yes. Martin, you raised a very important and a crucial point in relation to surety, notarial bonds, and so forth, you see. Because in the nature of credit, sometimes when you do the review, you will think that when the customer or the third party sign the credit agreement, then that's it. And then we just request the financial or audited financial statement or the bank statement. However, the suretyship speak to something else to confirm whether that person has got an assets or a notarial bond, it's got those properties and so forth. So very well. When coming to the suretyship, the requirement of a supporting document shouldn't be only the financial report, like bank. I will give an example with a bank statement, because on bank statement you only see the amount there, but now you don't know whether that particular person or a legal person signed surety has the property or asset to confirm the suretyship that has been signed. So in other way, if I understand, if then the customer has to sign the surety or provide the notarial bond, we need to request some additional information to minimize the risk.
Absolutely.
Okay, thank you very much. Yes.
You got to get, if it's a personal surety and you want to know, you understand the value, is get an assets and liability statement. What is the assets? Now you can check the assets. So I say, I'll sign surety because I own a house. Now you got to go and check if the house is bonded, encumbered, as they call by law. I don't want to take up too much time of this, but it's critical. So if the house is bonded, it's worth nothing. Then my surety is worth nothing if that is the only asset I held. A notarial bond, you get two types of bonds. Bond over movable assets, which is a notarial bond. That's stuff that can move. Desk, chairs, computers, machinery, things like that. And then non-movable assets, which is property, which is a different type of bond. The one you register with what's the name, and there's clauses and stuff, and that's a bond over property. And you can have a covering bond where it's just a value that is registered, or you can have a bond where there's money paid out to you, and that's of course a bond with a bank. Different story in completion, but you've got to check the value of the assets that is put up as collateral in a certain document that is given to you to secure the debt that they engage with.
No, thank you very much. Got you. Thank
Pleasure.
you.
Pleasure, Richard.
Perfect. Okay, great. So I think that we've covered the surety documents. And again, this would need to be discussed with your attorney to make sure that you are covering this. But what we're wanting to enable you with today is to ensure that even though you are not an attorney, or maybe you are an attorney, which is amazing, but you need to know what questions to ask to make sure that you are covered as well. So you may not need to know and understand all of the laws, but you may need to know and understand how to protect your business. So that is very important. Okay, so now we're talking about the ownership of property and goods. So as Martin mentioned earlier, there is a legal term for that, which was, I'm having a
reservation of ownership.
Reservation of ownership. Thank you very much. I'm not blonde anymore, but sometimes even I have them. Okay, so here you can see that the goods remain the property of the supplier until fully paid. But this is only if you stipulate it in your terms and conditions. If you don't, then it is very difficult to ensure. So make sure that you have that reservation of ownership clause as well as a way to track it. So that's very important to make sure that in South Africa, the retention of ownership clause, also known as a reservation of ownership, there it is, thank you very much, is commonly included in a credit application. Of course, if you are in a service type environment, you would not be having a reservation of your product because you can't get it back. So very important to make sure that if you are not in that type of tangible goods, you may not need this clause. Okay. Goods that cannot be used to settle rental debts. So you'll see that one of the questions we ask in a credit application, or what is recommended, is the property rented or owned? And if it is owned, we'd like to know if it's bonded, and or if it is rented, we'd like to make sure that you get the landlord's details. And the reason for that is the landlord should actually be informed of this clause as well, to say that if something happens and this customer does not pay their rent, the landlord cannot come and take your stock and use it to settle outstanding debts on their behalf. So very important that if you do trade with a customer and they are renting, that you let the landlord know of this clause. And so it's very important that you do that. So either the customer can let them know, but I think it is good practice that you also let them know, so that you make sure that everybody is aware of it. Okay, so very important. Then, of course, there's commercial lease agreements. So there's the rights and obligations that tenants have when they are leasing commercial properties from large corporates, for example, like Growthpoint. And they would need to then say, you could even ask for that agreement. If you see that they are renting, you can ask for their lease agreement and see that in the lease agreement, it doesn't already stipulate that any tangible goods or movable assets would belong to that company as well. So these are things that you can learn to ask for, to say, I'd like to make sure that I'm covering my basis, and or put a clause that says this supersedes that agreement. And again, you would need to then let that property agent or property management company know about that information. So very important around the lease agreements that have got to do with credit and stock. Okay, Martin, is there anything you want to add to that?
No, it's just that you must be so careful when you engage, Amy. It's like you're saying now, these property groups, they've got so many clauses, and because I just want the property, I sign it, and I don't know what I'm signing. In the meanwhile, you are signing a notarial bond, which says any movable asset that I have, if I don't pay you, you can come and take. And it sets you up for big problems, like you just discussed. We're going to run out of time, Amy, so I want to give you the opportunity to go through most of these things.
Perfect. Yeah. So you'll see that we're just talking about what you can do in a situation like that, what legalities there are around the reservation of ownership of your goods. And as I said, there are good practices that you should follow, which is being in touch with those property managing agents, looking at those lease agreements, as well as making sure that if they are renting from an individual, that person is aware as well. So very important to make sure that you do your homework from that perspective. Okay, then we get our credit agreement. So you as the credit provider, you are, as I said, you are the creditor, the person providing the goods and services, and you're allowing them to pay you at a later date. The debtor is the person that is going to be purchasing from you. So that is the names that you are referred to as the debtor. And this obviously, we're not talking about your ledgers. We are talking about specifically what you are called in the industry, so the terminology. Then, of course, we've got our payment terms. And what those payment terms are. We've got our interest or overdue payment rates that we would then include to say, if you pay us 5 days late, you get a 2%. If you pay us 10 days late, we will charge you 10%. And or if you've got settlement discounts, for example, if you pay earlier than what's expected, what will I do as well? So it's not necessarily only on the adverse side, but also on the proactive side. So you can then say, if you settle before your terms are up, I will give you a X amount of settlement discount as well. And that needs to be clearly stipulated. And then, of course, your maximum credit limits, how somebody would apply for an increase on their credit limit, what documentation would you need if they did increase the original terms that were agreed to, and or the original credit amount that was agreed to. So that also needs to be stipulated as well. So that is the increasing and decreasing of limits, as well as decreasing of limits. This is at your discretion as well, to say, if I decrease a customer's credit limit, do I actually need to inform them? And this is very important, because the answer is actually no. It's dependent on you. Obviously, there's common courtesy, and we very much believe that you should have common courtesy, but you don't need to let somebody know that you are decreasing their limit. And it could be for various reasons. It could be because they don't pay well. It could be that they are no longer in a valid business status, and therefore you're now putting them on COD to safeguard yourself. And so you would then need to say, this is why or when we would decrease your credit limit. And of course, we're wanting to be mitigating our risk as well, which is what TradeShield is there to help you with, to say which debtors are not going to pay you on time. And therefore, you need to start reducing their credit limit before they default on payment. Okay. And then we can avoid the judgments and. Okay. And then obviously, we're making sure that we explain how we would have our protection of person, what information, what practices have we got? If we've got ISO compliance, all of that would then need to be in your terms and conditions to ensure that the customer is also feeling comfortable, as well as the compliance with POPI. As well as, actually, we didn't add this in here, but we also need to ensure that there is compliance with regards to FIC. So you would need to add that in as well, your FICA compliance requirements, and or if you use third parties, you can include that information as well to say we outsource this process. So your information will be given to a third party, like a credit bureau, like a bank, like a FIC compliant officer, or even a POPI compliant officer, or legal attorneys as well. So this would need to be clearly stipulated. There can be, as I said before, no ambiguous lingo as well, to make sure that everybody fully understands that you may share that information with other suppliers in order to safeguard yourself. You're not doing it so that you can sign them up for a weekly newsletter from another company. Neil, yes, you are letting me know that there is a question in the chat. Thank you so much.
The question is habitual late payers, Amy. How would you force habitual late payers to pay early? Well, I can carry on for another 3 hours about this, but the quickest and most efficient way is to stop your service. With other words, put a hold on the account.
Yeah.
That's probably the quickest and the shortest way to do it. But make sure that your side is clean, that the client is not paying you because you didn't deliver the goods on time, you didn't get your invoices to them on time. 85% of the time the clients don't pay us. It's usually our own fault. But let's say in this side, you're the correct one, you've done everything that you should do, put their account on hold. Stop delivering the service. When we were working for Afrox, we just used to go and switch off their gas or not deliver gas. If they're a restaurant, they cannot function without it. So that's probably the most easiest and the most quickest way to get them to start paying you in time, on time. So if you say to them, listen, you got to pay me on the last day of the month. And if they don't let the next order go out. But you're going to have to negotiate that with your sales team, because they will again be up in arms against you, because they're not going to make their sales target. So there's a whole backwards and forwards thing around that. It's a very, very tricky little thing to have and talk to your business inside. But once you make a decision, stick to it.
Yeah. Absolutely. And I see that Sharif also posted to say it's not so easy to put an account on hold, but you also have to make sure that you're not recklessly lending. And you can notify them. You can say, you know, if this doesn't get rectified in X amount of time, this is the consequence. Again, we talk about consequence, and it's about outlining what that consequence is, so everybody's aware. And it actually filters down all the way until you're a child. I have 3 little ones of my own, and I always say to them, if you do this, you choose the consequence as well, to tell me what should happen. Is it that you're not going to have friends? Is it not you're going to have sweets? Or you're not going to be able to use any phone or anything like that, or TV, so that they understand beforehand that if you do this, that is going to happen, and then stick to it. So very important. If you don't stick to it, they will never take you seriously. So if your terms and conditions stipulate that if after a certain period of time this will happen, then this is what needs to happen. And that would be outlined in your credit policy. And we definitely say stay firm. And I can see Lavina said a sale is not a sale until the money is in the bank. Absolutely. So you'll see, Lavina, to answer that, we're going to be starting a new course later on in the year, which is going to be the order to cash process. And you know, making sure that everything in between that stage is a deal is not a deal until the money is in the bank. So very, very important as well. So very you know, you don't want to be giving away your stock just because you feel bad, and then nobody's going to pay you and you close your doors, and then everyone in your company gets retrenched, which I think sounds much worse. So the consequence of the consequence is even bigger than the requirement. But we know it's not easy, and it's easier to say than it is to do. But if it is clearly stipulated, you can have internal process to say, we're going to send you a letter, then we're going to phone you, then we're going to list you as a bad payer on a credit bureau's website, then we're going to halt you. That's completely up to you, but you must make sure that you follow those rules and regulations. Okay. And then Sharif said, how does it work with credit limit reviews? Do we need consent from the debtor, or just review on your recommendation? So you can review, and you should be reviewing your debtors book on a constant basis to make sure that it is either up or down. So if you are, you know, and TradeShield does this for you, understanding that if you have a lot of customers, it's impossible to review them on a regular basis. But what we go and do is we review them for you and tell you what you should do about that information. So we do not need their permission to review your own risk and your own debtors book. Where you may need to then get their permission is if you want to increase their credit limit. You do not need their permission to decrease their credit limit. But as I said earlier, it's common courtesy to let them know and the reason why you did that. And I see Martin has something to add to it as well.
Even in the increase, it's not necessary to get their permission. The one thing that you have to do is that when you go to court, you must prove that you've done an affordability study. With other words, I have assessed and I have made sure that Martin Petzer Pty Limited can afford the increase in the credit limit that I have just granted him, that I have just put onto his account. So I've increased him from 1,000 to 2,000 Rand, and I've based it on the following facts. Then allowed, then you can do it. So it's not necessary, but in the consumer world, of course, it's a completely different kettle of fish. I'm talking business to business here. All right.
Absolutely. So the last little bit that we have here is obviously that dispute resolution, which leads directly into this. What do I do? And so you need to make sure that those steps to resolve disputes is very important. And it could go either way. It could be, why didn't my invoice get paid? Oh, okay, I didn't give you the right information, which I know Martin says majority of the time when we don't get paid, it's because of something we may have not done or done. And therefore, we would need to make sure what is the process we'd need to follow if we have done something incorrect, but also what is the process to follow if you have done something incorrect, as in the customer. And that's very important to understand what's the difference and where do we go? How do we resolve a dispute between the debtor and us? Do we want to take it to the next stage of handing them over? Do we outsource that information to a collection agency? All of this would need to then be stipulated. And again, you need to then say, if you do use a third party to do collections, therefore you would need to tell someone. Maybe you do factoring and invoicing of your book. So all of that would need to then be in your terms and conditions, as well as arbitration and mediation options, which of course would be the first option, to mediate before taking out judgment. And then of course, termination. So arbitration and mediation says, let's sit down and have a discussion first, because we are dealing with people to people. And as we said right at the beginning, there's that trust, there's that relationship. So let's have a discussion, and you may want a legal person to sit in on that meeting with you, a mediator, a legal mediator. And then of course, what is the termination? So, how much period of time does somebody need to give you if they'd like to cancel a contract with you? What period of time do you need to give them? And all that information. So notice period, as well as automatic cancellation due to X, Y, and Z that is relevant in your business. So this would all need to be in your credit agreement. So what we've covered with you today is to make sure that you understand the requirements needed in terms and conditions, as well as credit applications, in order for you to make sure that you have the right documentation to secure what you're doing. You're looking at the risks that are involved, and you're complying with the law within the country. So all of that just tells you, go home and or go to work, should I say, or be at work if you want. Don't go home unless you really want to. But go and have a look at your own terms and conditions now, and say, now that we've gone through this with Martin and Amy, what information do I feel is missing? Or now that I'm now seeing the terms and conditions, I fully understand why we are asking for this, or why we have said this clause, or why my business needs this information, and why I can't open an account because my manager said no, and why I feel like they were being difficult, but now I understand. So as I said before, we can help and advise you. We can go through your terms and conditions with you, but we are not lawyers, and we are more than happy for, to help and guide and join and do whatever we can to assist you. But very important to make sure that you have an ironclad terms and conditions to protect yourself and your business. So we want you to be happy, we want you to trade, we want you to help grow the economy, but we also want you to be safe, so that when we do our next week's webinar and our next year's webinar, that we're all here together as well. So I will leave it there for today, and thank you again so much for joining us. Next week we have a very exciting guest speaker who is an attorney, who will be looking at how do we process liquidations, what is the liquidation process, who do we call, what do they do, and everything around a business being liquidated. We also have a very exciting guest speaker coming next month. I'll post that information as well, but we actually have CIPC coming to speak with us, and so that is a very exciting process. So I will then post that link as well. And if you have, of course, any questions, you are always welcome to join with us. Martin, I'm going to leave it there for you, if you don't mind. We have a fire drill in 1 minute, and being head of the department, I would need to make sure I don't let any of my staff burn. I don't think they'd like that very much. But thank you again so much. I do see there are some questions in the chat, so I'll leave it there for you. And I hope you have a wonderful Easter weekend. I almost forgot it was the long weekend. So a wonderful Easter weekend. And if you're going away, please travel safe and come back safe as well. Don't eat too many chocolate eggs, and just have a wonderful day.
I have your fire drill. I'll take others and carry on
Thank
with
you
the
so much.
questions and make sure that everybody is happy until they've all logged off.
Thanks, Martin. Okay, Martin, I did see, sorry, they said there's a slight delay in it. There was a question that was raised with regards to how capturing account information in our system, are we allowed a prefix on the customer's name?
I went back, I said, I don't understand what they mean by prefix. What do they mean by prefix, Amy?
Okay, perfect. So you have, oh, there we go. I see you have
Yeah.
answered them. Okay, and then it said, she said, Buttermello said, example, the customer is EST member and their name is Durban CC. Okay, so basically she's saying if a customer is registered as one name but trades as another.
The one is a trade style. Okay, so you can say Martin, or you can say Mr. Lawnmower, a division of Martin Petzer Pty Limited.